Can the executor sell the home when someone dies? Stick around. We're going to talk about it on Suits and Boots Legal Talk. Hey, Colin, it's good to see you again, man.
Good to see you too.
So I'm Luke Martin, one of the attorneys at Bimbo Davidson and Martin. Kolin Funk's here with me, one of our associates. So we're glad you guys have joined us. Colin does a lot of our estate administration, estate planning work, and I do a lot of our real estate work. So we're going to talk a lot today about how those two things kind of work together and some of the conversations that Colin and I have had, a lot of the common questions that we see around this. It's sort of confusing for folks because in North Carolina, we've got these two different kinds of assets that we see when someone dies. You've got probate assets and non-probate assets. And what the heck is all that? So we've talked before about estate administration and kind of did the 30,000-foot view of that. Today, we're going to drill down just a little bit into this one specific topic. Mm-hmm. So we have a lot of our clients who come in who have a deceased loved one. The real estate's typically the largest asset, right?
That's right. Yeah, here kind of more rural. We get some people who are more from the city, but yeah, it's a lot of people who are more rural, and the biggest asset is usually the land.
Yeah, and as from the closing attorney side, which is where I really come into this picture, what happens typically with us is, and thank goodness, we've got some good real estate agents that we work with, and the ones we work with a lot will call me and say, hey, I'm getting ready to list this property. Who needs to sign? Because that's really what it comes down to. Somebody's passed away.
Yeah.
And now the heirs want to sell the property. Who has authority to do that? And so we got to figure that out. And so we want to figure that out on the front side. And almost always what happens is I get a contract and the executor has signed it. Mm-hmm. And that can be a problem, can it?
That's right. Yeah, it really kind of ultimately boils down to if there's a will, what that will says. There's a very fine line. This is something that we've had to go through quite a bit with some clients of ours that, there's a difference between, the property being left to heirs versus the property being left to the executor. I know it's kind of counterintuitive. Why am I leaving it to the executor? I want, my kids to get it. But there is a difference. It's ultimately, the difference between your executor having the power to sell that property and then distribute those funds to your loved ones, or the executor not having that power. And sometimes it doesn't matter. Sometimes it's all the same, but sometimes it can be crucial and save a ton of money to do it a certain way.
So let's talk about this. Let's start from the broad and kind of work our way into the narrow. What is the difference between a probate asset and a non-probate asset? What does that even mean?
Yeah, so a probate asset is really at a very basic way of looking at it, something that the person owned in their own name when they passed away. So it's something that is going to go through their estate, something that the clerk will kind of have to monitor in the process of getting it switched over to, your loved ones or your heirs. A non-probate asset is something that kind of during your lifetime you have set up in a certain way that it transfers automatically at your death, and it does not have to go through your estate. So there's a small difference, but it makes a big difference on the back end for sure.
Or in our cases, specifically in North Carolina, real estate is almost always a non-probate asset, whether you've set up anything like that or not, right?
Yeah. So it really is one of those things where the North Carolina statute is drafted in such a way that it is a non-probate asset, meaning that at your death, whoever is going to get it, whether it be through your will or through the laws of intestacy, pretty much step into your legal shoes by operation of law of you dying. They're the owners of it at that point, regardless of your name being on the deed still. They're the owners of it. So there's some kind of red tape that goes with that, and we'll get into that. But yes, in North Carolina, these pieces of real property pretty much transfer automatically.
And that's crazy hard to imagine. So when a person dies, their property, their real property, when we say real property, we mean land, mm-hmm. houses, those kind of, and everything attached to the land, automatically goes to the beneficiaries under a will or to the heirs. If there is no will, it just automatically transfers. It doesn't go through the estate. There's no probate process required for that. It just automatically vests, title vests immediately.
Yeah, title vests, and It does. There's a little bit of nuance that goes into it in terms of, creditors' claims, and that's something we talked a little bit about in the 1% episode, whether it be Medicaid or, credit card bills or something like that. So it can be subject to some debts, but in that case, the executor doesn't have the authority to sell it. They have to kind of motion to recapture that for the estate. But yes, generally it's the heirs or the beneficiaries, and if anything, the executor is going to have to, by some operation of law, go through the clerks to recapture that asset.
And let me just say, because this is where, and I think we talked about this in the previous podcast. So if you guys haven't heard that one or seen that one, go back and check it out. I don't remember which episode it was, but it was on estates and estate administration. So you can check that one out. But one of the things that we talked about in that podcast that's super important from a real estate perspective is if you have inherited property from mom or dad, that property becomes yours at their death. And that also means that your spouse has to sign. So if we've got a lot of heirs or a lot of beneficiaries under a will, that can be really cumbersome to have all of those people come and sign. And so some of the things that we talk about in the 1% podcast, where we're talking about Medicaid liens and asset protection, really come into play and can really be helpful for narrowing down who has to sign, avoiding the probate stuff altogether and those kind of things. Okay, so mom or dad or whoever the loved one has passed away, we want to sell that real estate. What's the first thing the family needs to do?
So the family probably is going to need to go, come see me, and we'll kind of talk about what the next steps are. We'll just say everything's normal. There's the house that they owned, and then they had some bank accounts and stuff. So what we'll do is we will, if there's other assets in the estate that aren't the real property, we probably will need to go to the clerk and get something opened up. And through that probate process, we've talked a lot about the notice to creditors. That's definitely first and foremost. If we're trying to sell real property pretty quickly here after someone's inherited it, it's a good idea to just run this notice to creditors. And there is, a time limit to where if it doesn't get done for a certain number of years, then, it's kind of past that presumption. But I'd say run the notice to creditors. Then at that point, we kind of at least figure out what we want to do with the real estate, whether that's, sell it or, the people can keep it with the understanding that, they can pretty much sell it whenever at that point. And
one important thing to know that I set this question up, like what if they want to sell it? If they don't want to sell it, they really don't have to do anything, do they?
It pretty much is done. It's a good idea to go ahead and get something on file with either the Register of Deeds or the Clerk of Court just to establish that chain of title, whether it be through a deed or whether it be through an estate file or
future title attorneys will really appreciate you.
That's right. Yeah, that's one thing that we've had to deal with some messy titles before. So, when we're doing it, we just like to get a chain of title in place for any sort of contingency that could come up. And that really does involve, either doing another deed, recording an affidavit with the Register of Deeds, or getting an estate file open. So if you want to keep it, that's perfectly fine. There really isn't any rush. And if it's really just the real property, there isn't a large reason to go over to the clerk if you don't need to. The choice is always there. It doesn't hurt. But yeah, that's what I'll say is would we do something to get a chain of title established, and then, go on your way, and it probably won't make too much of a difference.
That's something that is really important, is to establish that chain of title. And that's not necessarily for you if you're keeping it, but for the future, anybody who might want to sell it. If you decide to sell it down the road, anybody in the future who owns it, they really need to see that chain of title. And those are just documents on record. There's ways, especially if there's a will. We need to get that will recorded. And there's ways we can do that without going through the full probate process. So it's very simple. It's very easy.
It is.
And we can get that will on record and show, okay, mom and dad wanted Joe and Susie to have this property, or whoever it is. And that way that title is on record and it's done. If we don't get that will on record, then the property passes through intestacy and may not go like mom and dad want it to go.
That's right. And kind of one of the things that, at all costs we seek to avoid is a situation where, you inherit your mom and dad's house, and you choose not to do anything. We're telling you, Matt, you may not need to do anything. It's smart to get that chain of title established, regardless if you want to keep it, because, it's a bad situation when you inherit mom and dad's house, you have kids, and then you pass away without a will, and then your kids own it. They do own it, but your kids want to sell it. At that point, they're going to go see Luke and I, and we're going to say, well, yeah, it's yours, but
we got a lot of cleanup
there's
to
a
do.
lot of cleanup to do in terms of, you're going to have to open, your grandparents' estate, and then you're going to have to open your dad's estate, and you got to track who's owned it for the history of the title. And that's kind of what we mean by chain of title. Who got it from who got it from who's giving it to them, and make sure they all had, clean title to give to that person. Yep. So that, the ultimate buyer or taker knows that they can, sell it freely.
Okay. So if mom or dad pass, the most important thing, call us. Give us a call. Let's talk about next steps, because sometimes maybe it is a situation where you don't need to do anything at all. But maybe it's a situation where we need to get some documents on record and just make sure we preserve the chain of title and keep that clean. Maybe it's a situation where we need to do a full estate and just probate the whole thing and work through that. So make sure to give us a call, and we're going to dive in just a little bit into the deep end here. So just kind of buckle up and hold on, because we're going to talk about some of the really specific things that come into play with real property in the estate context. And so if you guys, anytime on these podcasts, when you're watching or listening, if you have questions, our emails are available on our website. Leave us a comment on YouTube or Facebook. Yeah. We'll be happy to answer questions or engage with you somehow and get your questions answered. But so as we go into this deep stuff, and as we get into, you may feel like you're drinking from a fire hose just a little bit, but this stuff is stuff we deal with every day, and I know you guys don't do that every day, so some of this stuff can be kind of dense. Not that we try not to be dense, but the topic can be. So
That's what we try.
That's such a dad joke. Don't laugh at that. What comes up, we've got an executor who's signed a contract or something like that, and then we go look at the will and see, the property was left to the children or whatever. So in the real estate context, and one place where you and I have had a lot of discussions, is the executor really doesn't have any authority to deal with that real property. Mm-hmm. So whenever we have an executor who wants to sign a contract or sell the real property and divide the proceeds or something like that, we have to look at the will, and if the will leaves that real property to two of the children, then those two children individually have to be the signers to sell that real property. The executor really has no authority to do that. Yeah,
that's right. It's, that is kind of the two people who are making the transaction go is the heirs in that, or the beneficiaries in that situation. And it's never a bad idea to have the executor sign it if the estate is still open, but it's really just to kind of make it to where the estate at that point, whether it's being reopened, can't really get a hold of that. If the executor is signing it away, I kind of think of it as they're not necessarily signing the title away. They're kind of, basically ending the estate's right to recapture that property later.
And here's where it gets a little confusing, a little complicated, because we are, as the real estate closing attorney, we are going to have the executor sign that deed. Mm-hmm. And you say, well, you just said the executor doesn't have any authority. Why would we have the executor sign the deed? Well, because there's this right of the estate to bring that real property into the estate to pay claims of creditors. And talk a little bit about that process and what that would look like.
Yeah, so that kind of depends on what the will says as well. But long story short, you basically have what the statute says is, the executor has the ability to recapture this property for the very limited purpose of paying claims. So, in a situation where, it's just not convenient for the heirs or the beneficiaries to sign this deed, there's a whole bunch of them, it's not convenient for them to sign it. They just say, well, can't the executor do it? And there's no claims against the estate. No, the executor can't do that. It's going to have to be the beneficiaries in that situation. Now, if there is a situation in which the estate's opened and there's $50,000 in debt against the estate, and there's not $50,000 cash or other assets that can be sold to cover that, then yes, the executor can kind of go through a special proceeding with the clerk of court at that point and work out a way to get it sold. And the executor can sign in that situation, but outside of the will giving the executor express consent to do that, that's the only way the executor is going to be able to do that if it's needed to pay claims.
That's through a court proceeding. That's not something that just falls into place. That's a petition. And
it's quite a bit of filing. There's upset bids, and there's a lot of stuff that goes into it. So it really circles back around to come in and see us for your estate planning, because we can talk to you about what you want to happen, and we can set it up to make it to where it can be as easy, or go through the kind of the rigors of what the North Carolina statute has to say.
And this is where I think it just like you were just saying, it's super important to go back and look at that podcast on the 1% purchases that we talked about with David, where you can plan for these things and avoid these things, because where there's the biggest place we see this problem is Medicaid.
Yeah.
So if your loved one has had to be in long-term care and had to use Medicaid, not Medicare, there's a difference. Check out that podcast. There's a difference between Medicare and Medicaid. Medicaid will actually put a lien or a claim on that estate.
Yeah.
And then the executor is forced to go after the real estate that the person who died had, bring that into the estate, sell it to pay that Medicaid lien.
And that's regardless of what the will says.
Yeah.
I mean, that's you. I could leave my house to Habitat for Humanity, but if Medicaid has this claim against my estate and my house is the only thing in it, my executor doesn't have a choice. They're gonna have to recapture that. They're gonna have to sell it. And, there's more often than not, the entirety of the proceeds of that sale are going to go towards that lien, and sometimes not even cover it.
So when you hear things like the nursing home's going to take my house, or the state's going to take my house, or any of those kind of statements, this is the process by which that happens. And it's not really the state or the nursing home. It's just they put a claim on your estate, and then your executor has a duty to pay that claim, and they have to pull the house in sometimes to do that. Now, there's even in those cases, there's things we can do to try to fight that and work around that, but it's really difficult to deal with that on the backside. It's much easier to do something like the 1% or something like that we talked about in the previous podcast on the front side. So we're talking, when we talk about those kind of things, we're talking about probate avoidance, so we get around some of these things. And one of the things that's important from a closing attorney perspective is, you've heard us say, whenever the person passes away, the property automatically goes to their heirs or automatically goes to their beneficiaries if they had a will. And those people are the only ones who have authority to sign in the limited circumstance where this executor thing where they haven't had to recapture or something. So those people are the only ones who have authority to sign. But whenever they come to me and they say, hey, we're ready to sell this property, and maybe mom died a few months ago or dad died a few months ago, one of the things I'm going to say is, okay, have you opened the estate? And now you're looking at the screen cross-eyed going, wait a minute, Luke. You just said the estate has no authority over the real property, and now I want to sell the real property, but you're saying, have you opened the estate? What the heck does that matter? Well, it comes into this claim of creditors and these liens, because the estate has the right for up to 2-3 years to come back in and grab that real property. So if we sell the real property in between 2 and 3 years from when mom and dad died, we need to open that estate.
Yeah.
So if you don't mind waiting, maybe we don't have to open the estate.
That's right.
But if you want to sell it immediately.
Yeah, if you're wanting to sell it within, a couple years, then just get in and get an estate done, get that notice to creditors run. It doesn't have to run too long, just a couple of weeks in the paper of kind of general circulation in the area. And, once that comes back clean, no claims come forward, then, there's not an issue.
And here's a little secret that a lot of people don't know, that the statute in North Carolina says that once that creditor's notice is published the first time in the paper, so the creditor's notice, how long does it run?
It runs 3 months.
3 months, so like 90 days. So
it runs for 4 consecutive weeks, but they have 3 months to put their claims in.
Okay, so it runs 4 consecutive weeks, and then they've got 3 months to make a claim
Submit
on the
their
estate.
claims against the estate, yeah.
So when I say that creditor's notice has to run before we can do a closing, a lot of people think, oh, man, that's going to take 3 months. I don't want to wait that long. Well, you don't actually have to. So the statute in North Carolina says that once that notice runs the first time in the paper, that title can convey from the beneficiaries or the heirs to a third-party purchaser for value with no cloud on title. Now, we've got to be careful there because that creditor's notice hasn't run. So what happens if we convey that real property? The executor's going to sign off saying, hey, I don't need this on the deed. They're going to sign the deed. Even though they don't have authority, they're signing away their right for that recapture. And so then we're going to convey the property. Technically, those proceeds are due to the heirs or to the beneficiaries because it was their property. So the estate signed off its rights to it. The heirs get their money, and now everybody's gone. And all of a sudden, a couple months later, Medicaid slaps that claim on the estate, and we're going, now what do we do? And so in those circumstances, we really need to be careful to say, okay, are we expecting any claims? And do we need to escrow these proceeds? And in case they need to be brought in to pay claims of creditors, we'll have them, right? We've done that sometimes.
Yeah, and it's really just if we have a screaming deal on the house, we just want to sell it, fine. We can go ahead and sell it after this first one's run. But, with the understanding that, look, it's really not money in your pocket at this point. It's just exchanging the asset of real property for the asset of cash. And we're going to hold on to that cash until this notice of creditors period is completely over, because the last thing we want to do is distribute this cash out to the beneficiaries. And then, here comes a creditor and there's no money.
And we got to make a phone call and say, that check we wrote you, could you bring that back to the office? Because that's never
not a
good thing.
Call,
and nobody wants to go through that. So we want to make sure we protect you guys as sellers. We want to protect the buyers. We need to make sure we convey good title to that property. Yep. A lot of times what folks don't realize is whenever you sell real property, you're actually signing what's called a general warranty deed. And that deed says that you have good title to the property. You have the right to convey that property. And so if you convey the property over and then the person who you sold it to gets a letter in the mail saying, hey, you don't actually have good title, then you've made warranties as the seller. And we, as your attorney, we want to avoid having any problems on the backside of those closings. We don't want to have any problems with the estate's department or the clerk of court or anything like that either. So we want to make sure all this stuff is kind of handled up front. So we get the claims, the creditor's notice run. We can go ahead and do the closing. Maybe we have to hold the cash. Maybe we don't. Tell us about circumstances in which the executor may be able to sign the deed. So, we talked about where the executor files this action with the court and claws that real estate back into the estate. But other times, there's things they can do in the deed to make it where the executor can sell that and maybe distribute proceeds.
Yeah. So, in your will, if that's what you're wanting to do, essentially, we will and this is what I was saying earlier, sounds kind of counterintuitive. We're going to go ahead and in your will leave that real property to the executor in their name as the executor, of course, and have them just say, I leave it to my executor to be sold and the proceeds split between these people here. So in that situation, it's enough of a difference in the eyes of the law to allow the executor even though the beneficiaries of your will are going to be getting the proceeds, to allow the executor without the beneficiaries having to sign that deed. The executor is going to be the one who signs that deed, and then, by the terms of the will, they're obligated to distribute those proceeds to your beneficiaries. But if you have 6 kids or something like that, and it's a single family home, it's not feasible most of the time to have 6 of your kids get your single family home or something like that. So in that situation, what I typically say is, like, there's a couple ways we could do this, but the easiest is going to be just leave it to your executor, have your executor sell it, and then have your executor split those proceeds between your 6 kids. And that doesn't mean, one of your 6 kids can't buy it if it's, if they want it, but that's going to be the easiest way in that kind of situation. And there's situations where you have 6 kids, but you have 1,000 acres. That's pretty easy to split up 6 ways. We can do that.
1,000 acres.
But a single family home 6 ways, that is what I would, tell people. Say, just leave it to your executor and give them the ability to sell it. So they have to sign the deed. So, Tommy in California and Sandy in South Carolina and, Matt up in Maine don't have to come down and sign a deed or do a mail away deed or something. It really just can streamline the process quite a bit.
I see what you did there with the first letters.
That's my little mnemonic there.
I like that. So you can always remember that. Matt and Maine, watch out.
Yeah.
So anyway, we've talked a lot about the real property and as it relates to estates, as it relates to probate. And so talk just a little bit. We've covered in depth the 1% purchases and Medicaid asset planning, but maybe Medicaid is not an issue. Maybe that kind of planning isn't what we need. But what are some things that people can do on the front side? So as in their estate planning, how can they avoid this problem with probate and having executors and having to run creditors notice? What are some options they have in the estate planning realm to avoid that?
Yeah, so really it kind of circles back to the probate versus non-probate asset. This is kind of a third thing of it's not your asset at all. That's kind of the goal of probate, to get things out of your name so that when the time comes and you pass away, it doesn't have to be listed anywhere. So a thing that we like to do a lot is it's kind of in the same light as the 1% deed is the life estate deed. A life estate deed is going to be a deed that you're giving your property to, say, your kids. But in that deed, we're carving out an exception in there that says, I can live there for the rest of my life. That's the life estate. So
if it's my house and I'm living in it, but I want this house to end up going to my children, I do a deed, give it to my children, but I reserve a life estate.
That's right. Yeah, and it's typically one of those things where I'm going to recommend that to people who are pretty certain they're going to live in that house for the rest of their life. They say, I want to leave it in my will to my kids. I say, well, there is a way that we can kind of get this out of your estate altogether, not have it be subject to any creditor's claims, and it's this life estate deed. It involves you signing a deed, and you're going to basically sign your whole title away to your kids, except for this one little carve out here of you're allowed to live there. And, it's not saying that your kids can't sell it, but whoever they're selling it to is going to be subject to your life estate there. So it's one of those things where it gets it out of your name completely. But it still allows you to live there for the rest of your life.
Well, and it gets it out of your name at your death. But while you're alive, you still have the right to use it.
That's right.
You still have the right to invite people in and out. I mean, it's still yours. As long as you're living.
That's an important part of it too. It's that it functionally, your use of the land won't change. It really is just an at the death, and you might say, isn't that the same kind of thing? But this is kind of putting it beyond the presumption of these creditors, just because they're not going to take that into account when they're lending you money, essentially, kind of thing.
So we, when we do this, one of the really convenient things about it is if you were to just convey that, let's say you just want to give the property to your children, and that may be okay. Maybe we talk about that. Just do a straight out deed and say, here, children, you can have it. Maybe that's something we want to do. But when we start doing that, we've got some basis issues to think about and tax issues to think about that. It's way too much for this podcast, but it's really complicated. When you do gifts, there's benefits to people who inherit property, and so you really want to think about that and talk to your tax advisors. We can talk through some of that stuff with you. So that's why we advise these convey on death deeds, whether you call it a life estate, whether you call it lifetime rights. All that stuff's kind of the same idea. Another thing that we do a lot of times is our trust, right? Those are probate avoidance tools. Talk just a little bit about trust.
Yeah, so trust can be their own kind of legal entity that you're setting up while you're alive here. So, if there's no claims against your estate or anything like that, and you draft this trust and you transfer all your assets to the trust, that's very important. That's the whole thing. Some people, will set up a trust and then just not transfer their assets to it. And I don't know if it's because they're misinformed or
pointless,
what, but the whole point is to get them out of your name personally and move them into the trust name. And that's not to say that you can't manage those assets still or still live in your own house. A lot of times what happens is you draft a trust, you become the trustee of your own trust, and the trustee is really the person who makes the decisions for the trust. So, kind of look at it as, obviously you can't take your house out of your left pocket and put it into your right pocket. But if you can kind of see the illustration there, that's what it is. You're taking it out of your personal pocket and putting it in the trustee's pocket. And in that situation, there is some nuance there with claims against estates and stuff like that for revocable trust. For irrevocable trust, you're more than good. For revocable trusts, it can take it out of the estate and have it be kind of not even a non-probate asset. It's really just kind of outside of the estate's purview.
And there's so many things that we can talk about on trust that we've talked about. That'll have to be a separate podcast because there are revocable trusts, there's irrevocable trust, there's asset protection trust, there's self-settled special needs trust. There's all kinds of different options when it comes to trust. And one of the more helpful ones may be a Medicaid asset protection trust, which are things that we can do as well. So stay tuned for podcasts on that. Man, thanks so much for taking the time to talk today.
Absolutely.
And if you guys have any questions, like I say, leave them in the comments, send us an email, just get in touch with us, schedule a consult with Kolin or I, and we would be happy to talk about this stuff. It's so much easier to fix it on the front end and we say this all the time. so much easier to fix it on the front end than it is to fix it on the backside.
Yeah.
I mean, it may cost a little bit of money now,
but it'll pay dividends on the back end.
Way dividends on the back end. And I know that we're scary attorneys and nobody wants to sit and talk to us, but we really try not to be too scary, and we try not to be intimidating. And I know this is like drinking from a fire hose.
And that's what I think. One thing to kind of bear in mind if you're coming to see us, not everything that we talked about here is going to apply to everybody.
That's
right. There may be a small, minuscule portion of what we talked about today that may apply to you, but don't think under any circumstances that you come in and all of what we talked about today is going to apply to you. So we're trying to be as broad with these as possible, just to not have it so much as drinking from a fire hose. It is a lot of information. We can definitely respect that. But yeah, just know that my goal, and I think Luke's goal too, is when people come in to see us, if they're leaving saying that was a lot easier than I thought it was going to be,
that's what we want.
That is a successful meeting, and I found a lot that is what people say. So come and see us if you have questions, and we're happy to help.
It's really not as bad as anytime there's something that we're worried about or anxious about. My tendency is to just avoid it. And if your file is one of those that I'm anxious about, I'm sorry, because it's probably sitting behind my desk and I'm just like, oh no, what am I going to do with that? So we all do that. And so it's the same with coming to see the attorney about your estate planning. It's something that people don't really necessarily want to think about. They want to put it off, but it's so easy just to take care of it. And we really do want to help you guys. That's what we're here for, is to serve you guys and make sure and take care of you. And we do want you to leave the office thinking, man, I'm really glad that I got to meet these guys. I'm really glad that they're taking care of this. So give us a call, leave us a comment, like and subscribe to our YouTube page and our Facebook. We're here to help. So guys, give us a call. Let us help you. So thank you so much for watching, and you guys have a good one.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.